If you want. Welcome everyone to May's risk reduction risk management class. I'm pleased to see many of you on the call, and that's great because we got two very important subject matters to cover. One is the broker file checklist and a couple of forms that some people on this call have some questions about, and I want to be sure to explain them and why those forms are required, walk you through those forms again, and maybe address any issues anyone might have with those forms. And then wrap up the class with an overview of some of the selected forms that have been revised. CAR revised over 60 forms for the June release. But the good news is a lot of the revisions were simply putting the word housing provider in place of landlord. So a lot of the revisions are taking advantage of, I guess, the politically correct stance, and we no longer use the term landlord officially. And so that's what some of those revisions are. I'm not going to spend much time on those. I'm going to talk about some of the revisions that impact your transactions. And in most cases, these forms have been improved and maybe simplified in the sense that they've better explained some of the provisions. So with that, let me jump right into the presentation. Let me open up my PowerPoint. First, I got to share the screen. Share. Okay, everyone can see my screen, I take it?
We can.
All right, slideshow from the current slide. Okay. Of course, as I always start every class with, if you have any questions at all, whatever it might be, I'm here to help. So the best way to reach me during business hours is my direct landline, which is the second number on the screen, the 858-201-7115. That'll ring at my desk. I return calls. And if I don't pick up, I'm probably on another call. Leave a voicemail, and I will call you back. Of course, you can always email me. That's my email address. And then evenings and weekends, if you're working, I feel I should be available. Sometimes answering a question makes your life simpler and ultimately mine, because any problem you might encounter later, we address while you're writing the offer or meeting with your clients. And I know that happens on weekends and evenings a lot. So never feel bad to contact me. If I am awake and I take the call, I'm not being interrupted. I can promise you that. If I'm doing something that I don't want to be interrupted, like, for example, this morning, getting ready for this class, I won't take a call for an hour or two. So don't hesitate. Call me evenings and weekends if you need to. The cell number is there on the screen. It's best to text me, and then I'll return your call or alert me that you're trying to reach me. And my phone, I keep it near me all the time. I sometimes have the ringer off for sake of my family and where I happen to be located. Okay. Let's jump into today's class. A few very important forms. I want to talk about a couple of forms that I have successfully used. Our E&O company has successfully used. Our attorneys in the past have successfully used. And that is why we make these forms required, because in the end, it benefits the client and the agent and brokerage. So let me show you the forms that I'm talking about. First, I want to talk about the agency relationship form, the AD form, the CAR form. I'm not really going to teach that form. That is a CAR form. Law requires that form. Anytime you enter into a contract with a principal, you have to have them first execute this form. And so you're all familiar with that. I know that. We have an addendum to that form. Now, why do we have an addendum to that form? I can tell you why. In the agency relationship form, it specifies what a seller's agent's duties are, what a buyer's agent's duties are, and then ultimately what an agent who's a dual agent's duties are. And the key word that can get you into problems is utmost care. That is a very general term, and courts, absent limiting that, have held agents to a very, very high standard. And so to rein that in a little bit, we are not the expert in all things. We are not appraisers. We aren't property inspectors. We're not tax specialists. But yet that information has a significant impact on, or potential impact on a client. And if we owe them the utmost care, one could argue we need to make sure they're taken care of relative to not buying a house smaller than they thought it was. They're not buying a property that has some physical problems with it that they would have never bought had they known about it. They're not buying a house that there are tax consequences as a result of that purchase. So because this is such a broad term, and because there have been successful lawsuits, when the care is not limited, we want to limit that. Now, I'm not advocating that you tell your client, look, I'm not doing anything except write the offer, close the escrow, and send me my check. Not at all. What I'm advocating here, what I'm suggesting to you is these are the things that we're going to talk about are the things you should not be doing anyway. The problem is the client has a right, a legal right, to assume that you are doing it unless you specify you are not. Now, Carr knows this. There's nothing on the form that I'm about to show you that is contradictory to anything that's on a Carr form. But what attorneys who represent real estate companies and what E&O companies know is that redundancy is how you win lawsuits. If a limitation appears once in one form, and that's the only place, the client has successfully argued, well, that wasn't pointed out to me. I didn't see that. But when it's on multiple forms, that argument falls on deaf ears. So I want to stress two things. One is I'm not advocating you're telling your client we're not going to do a good job and take care of you. In fact, I'm going to give you dialogue on how you use the limitations of what you're going to do to enhance your representation of the client. And then secondly, I'm not advocating that you not do anything you shouldn't be doing anyway. I hope that came out right. In other words, you should not be discussing, the physical condition of the house from an expert perspective, because you're not an expert. You should not be talking about taxes. You shouldn't opine on where the property line is. You're not the appraiser, that sort of thing. So that same statement, agent represents both sides. Okay, so what's the form? The form is the addendum to disclosure regarding agency relationships. This form first came about. I've been doing what I've been doing for nearly 25 plus years. And over the years, 3 different owners, you can only imagine your E&O gets renewed every year. I've dealt with a handful of different E&O companies. Our current E&O company, which is a pretty good company, by the way, I have dealt with multiple times in the past under both owners. This form was suggested and developed by Cress. That's our current E&O company. This form wasn't something Walt Klein dreamed up. Cress came to us and said, we need all of our insured to be sure that their clients are informed as to the limits of what your responsibilities are. Cress has used this form. We have used this form successfully in claims. So that's why this form is a part of our required documents. This is a almost requirement by Cress. Cress really insists that we do what we can to protect ourselves and mitigate their risks. And so that's where this form came about. So, first of all, we do agree to do a good job and exercise due diligence and perform reasonable efforts. We're not saying we're not going to work. But we do want to limit the scope of what we're going to do, and that's limited in the terms of this agreement. So there's the paragraph and by the way, much of this paragraph comes right off of various Carr forms. So we're not going to determine what the right purchase price is. That's between the buyer and the seller, not us. We're not going to guarantee the condition of the property. We're not going to be responsible for defects on the property that aren't apparent to us as a result of doing a visual inspection. We're not responsible for cracked slabs. We were once sued because there was evidence of settlement, and part of that evidence was drywall damage behind wall hangings. And we were the listing agent, and we didn't disclose the damage to the drywall behind the wall hanging. If you're familiar with visual inspection guidelines, you do not remove pictures from walls and inspect behind the walls. That's in the code. So we're simply pointing this out to the client. All right. If I sound a little preachy, I want to be sure you're comfortable. All of you are comfortable with this form. It's not a shirking your duties, your care. It's clarifying them. We're not going to inspect repairs or take responsibility for repairs performed by others. We're not going to look at, identify boundaries or square footage. We're not going to verify inspection reports or representations of others. What's in the report stands on its own. We don't verify what's in the reports. By the way, let me back up and just give you a little brief idea of the dialogue. So when you're talking to somebody, your client, and you're reviewing this, you say, look, I'm not an expert on property lines. I'm not an expert even on square footage. Now, appraisers, they do measure for the property. You can hire an appraiser to get the square footage. You can hire a surveyor to determine the lot line. If that's important to you, I don't want you to rely on me because I'm not your expert in that area. I'm an expert in real estate matters, not in property lines. So let me know if that's important. I have a form for it. That's the BMI. I'll talk about it in a minute. And I'll make sure to help you get that addressed. So in your dialogue, you're telling him you're not responsible, but you're not walking away from it. See, that's the point I want to make. Okay. We don't provide legal or tax advice. We don't inspect off-site areas of the property. Imagine if we took on that responsibility. I've had clients, upset buyers who later found out that there was a problem a half a mile from the house and actually had the position that it was your agent's responsibility, the agent who worked for us, to tell me about a situation that existed a mile away, half a mile away. If you know of a problem a half a mile away, you probably should disclose it, but you don't drive around the neighborhood and look for problems. But yet the buyers sometimes assume you do. And so this stops those kinds of claims in its tracks. Okay, we don't review permits. If permits are important to you, I can provide a number to a service that researches it for you. I can direct you to the proper building authority, the building department that can verify the permits. I'm happy to even drive you down there if you want. So if that's important to you, let me know. But I'm not an expert on whether a property is permitted or not. I didn't own the property. I didn't perform the improvements. So you don't want to rely on me if that's important. That wouldn't work for you. You want some help in getting it from information from an expert. See, that's how the dialogue works. Inspect public records for title, investigate adverse, geological conditions, hazardous substances, roofing, heating, air conditioning system, all of that. And then finally, we provide any advice or service that beyond the expertise or education or experience required to be a real estate licensee. So that's simply the form. They sign it. And I can tell you, half this company's some of these agents on this call have been using this form for 20 years. And it's no real problem. If you're having any challenges at all, call me one-on-one. Okay, the BMI. I can tell you there are people on this call who've avoided lawsuits, even ones that have been filed. They got dismissed because of the BMI. Now, if you use the BMI, you have to be aware of the BSI. So what is that? Let me explain that to you. So what is the BMI? A BMI is a form where the buyer identifies anything that goes into their decision about whether they're going to buy the property or not, that they want to be researched. Now, the BMI is not a repair request. A BMI should be given to the client if not before, immediately after the offer is accepted. Okay, so congratulations, you got the house. Now, is there anything about this purchase that you are concerned about that you want to make sure is addressed? You know, sometimes they're going to say, well, I want to make sure the house is in good shape. You say, well, that's what a physical inspection's for. If you want, write down physical inspection on this form. A lot of times they won't. I'll tell you what they say most of the time. Those of you that have been using this form, you know, most of the time they say, no, nothing special. I've had people tell me, buyers making claims, that they told the client they didn't want XYZ, and now the house has XYZ, and they never would have bought it. And that's a verbal he said, she said. So this prevents that from happening. But that is a serious claim when the buyer says, if I'd known that smokers lived next door, I would have never bought this house. If I'd have known that this house was on septic, I would have never bought this house. And my agent knew it. And when I talked to the agent says, we never once talked about septic. I've sold a lot of houses, not too many lately, but I was a pretty good producer when I sold houses. I don't think I ever had a buyer say to me, oh, by the way, I don't want to look at any property. I don't want to buy any property on septic. I mean, sometimes when they find out it's on septic, they don't want the property, but it's not the kind of thing that a typical buyer, what are you looking for? Well, one of the things I'm looking for is a property that's not on a septic. They're not going to say that. After they discover it's on septic and they didn't realize it, now they say they said it and someone needs to pay for it. So this form prevents those kinds of claims. All right. So usually the buyer has made an offer, and then you identify the property. And then these are usually, things regarding the property specified. Now, if they say none, then they write none on the form. What you do is you create a text field for this form, and then the buyer types in what any concerns they are. We had a buyer one time list about 10 or 15 different inspections that they wanted. Instead of using the election of inspections, the agent listed them all on the BMI. When the buyer found out he had to pay for the inspections, he said, no, never mind. So absent a BMI, we would have never discussed some of these inspections. And after he bought the house, when he discovered radon gas in the house or asbestos in the house, he would have said, I didn't want a house with asbestos, and my agent knew it. So you sort of bring that to the surface by asking them to fill in a BMI. Again, I have stopped claims multiple times. There are people on this call who probably are in love with the form BMI because it saved them a lot of anguish. So it's a very good form. Once you use it a couple times, you get the hang of it. And again, it lists a bunch of stuff we're not responsible for, which is, this is on a car form, by the way. So notice how similar this is to the Remax Connections form I just showed you. We're not asking you to say you're not responsible for anything that you should be responsible for. That's the point I want to make. So the buyer, when he fills out the BMI, he's represented, he's disclosed any of his material issues, and that we have a right to rely on it. This is a very good form. Now, if the BMI says anything other than none, and you don't do something about it, the BMI becomes a loaded gun. Yeah, I told my agent I didn't want to buy a house with asbestos, and he didn't do anything about it. And now I find out I got asbestos in the house. If asbestos, concerns about asbestos is on the BMI, you've got to address that. Now, often it's addressed because you got to be an asbestos inspection. The inspection's in the file, everything's, super, no problem. If they end up saying, hey, by the way, we need to get that inspection for the asbestos, well, I don't want to spend $400 to do that. No, never mind, I don't want it. Well, okay, well, then let's waive it and let's do a satisfaction of investigation. Anytime anything other than none is on the BMI, then use the the Remax Connections form, satisfaction of investigation. You do not need the form if none is on the BMI, or whatever's on the BMI, you have documentation that has been investigated by the buyer. But absent that, then do this and identify the buyer and the property, and then the date of the BMI. When this was created, again, it was just created with the blessing of our attorney and an E&O company that we were with. They said, you know what, the BIE is real close to a BMI. And a lot of times agents or buyers rather will list off 10 different inspections and they check them all off. But then, like I said earlier, when they find out they have to pay for them, they say, oh, never mind. Well, they should be waived, and you can use this form to help document they've changed their mind. So, so if there's a BIE, this is a great form to use as well. And then, the BIE, as you're familiar with, lists all the different inspections that a buyer might want, and they check off. And sometimes I've seen quite a few of these checked, and frequently not all those inspections were obtained. Not so much because the agent wasn't paying attention. It was more likely the buyer changed their mind, because there's a cost to most of these inspections, and the buyer ends up not wanting to pay that cost. So the BSI simply says the buyer has completed their investigation regarding the issues they've raised, and they have fully satisfied themselves, and they either have elected to waive the inspections or, like I say, have satisfied themselves about it. And the buyer's satisfaction is based upon the buyer's own evaluation, not on anything we assured the buyer not to worry about. Buyer representative carefully reviewed it and considered everything. And okay, now at this point, before we jump into the car forms, does anyone on the call have any concerns or questions? Because I would love to address them now.
Well, Mingrit has a concern.
Yes.
And that is when her client asks what are examples of material issues, and then she gives them examples. And then since she mentioned it, the clients decide they don't want that house with that, even though it wasn't an issue with other homes that they looked at. Otherwise, that would have probably never been an issue.
I'm a little confused as to the layout. Maybe one-on-one we talk a little bit about it, but I'll say this. If an issue is brought up and the client says, oh, never mind, I don't want the house, imagine if they got the house and discovered the issue. So what I'm hearing is, okay, so they say an example. If they want an example, the simplest example is, well, for example, the physical condition of the house, because we're going to recommend a physical inspection on every transaction. If they got school children, do you have any issues about whether or not you're in the right school district? So it's better than giving examples. It's to re-explain what a material issue is. It's anything that you would consider important as to whether or not you would want to continue with this purchase. That's probably the best thing. And if you're still having trouble, give me a call and maybe I talk to them. I don't know, those of you who are using the BMI, I don't get that many questions from them that are saying, my client didn't get it. My client doesn't know what I'm talking about. So explain it, when you're buying this house, there may be some concerns you have. You would never buy a house if, and then you pause. Well, if the roof leaks, okay, well then put that down. And now, the physical inspection might say, check on roof because it's an older roof. And now you can say to the buyer, listen, you did express a concern about that roof. Do you want a physical inspection? Does that help you, Ingrid? You can unmute yourself if you want to explain.
It's just about how we present it to our clients, because to me, when I was reading it over, it says the following are material issues to the buyer. And then they're like, well, what are material issues? And then I say, oh, well, they're this or this or this. And then they're like, oh, yeah, well, I don't want a home like that, and then you're like, well, you never said you didn't want a home like that with those things. And so that's where it comes up.
Well, I would be careful about, not making a minor thing a material issue. I mean, a material issue is in the eyes of the beholder, but I wouldn't list small things like maybe you don't like the wallpaper or something. I mean, I would, that's not, that could be a material issue if the buyer says it is, but it's not an example I'm going to give. Use the physical condition of the house in general. You could use the roof situation as a house. It could be, and again, you're giving an example, could be you're concerned about the roof and how much longer it lasts. Well, that roof's practically new. Well, in that case, you probably don't have a concern. Yeah, that roof is pretty old looking. Yeah, I am worried about the roof. Well, then we might need to get a roof inspection if you'd like. We'll have the physical inspector give us some advice. Does that help you a bit more?
Yeah, I think I'll just stick with how you said, just a generalization of anything you would consider important for the
Yeah,
purchase.
something that you would probably not buy this house.
Yeah.
And you're trying to pull out things like, I don't want a house with septic. All right, we'll put that down, and we'll explore that once we get into escrow.
Thank you.
Libby wants to know if you should use both the BIE and the BMI.
Well, the BMI is required because I've used it successfully multiple times. And if I can prevent a lawsuit, it saves you money and it saves the company money. I don't require the BIE, but it's a very good form. Yeah, using both, not a bad idea, but I'll leave that to the individual agent.
Ron Wilson wants to know, do we use the BMI and the BSI to our buyers or the buyers of our listing?
Oh, that's a great question. Thank you, Ron. I meant to say that and I didn't. The BMI is only required for our buyer clients. We have no duty to advise a non-client. We have a duty to disclose, so the BMI does not affect disclosure. So whether or not a buyer wants to buy a septic house or not, or a house with a leaky roof or not, that's between the buyer and the buyer's agent. That's not between you, the listing agent, and the buyer. So short answer, Ron, BMI not required. In fact, I wouldn't even recommend using it for your non-clients. When only your buyer. When you represent the buyer, then the BMI. Same with the BSI. And again, the BSI only in conjunction with a BMI that says something, and it has not been addressed because the buyer changed their mind. That help, Ron? Yeah, great question. Thank you.
Lisa Herndon wants to know, what about the BIW? That goes with the BIE generally. So do we fill out the BIE and the BIW and the BMI and the BSI? It's a lot of.
Well, if you're doing a BIE, then it's an abundance of caution to have, and they don't do an inspection. In other words, if they do the inspection, then okay, they got the inspection, they got the asbestos inspection, great. Now the report's in the file, but they put asbestos down, environmental, and they decided not to do it. So the waiver's excellent, and the BSI is also excellent, and it's redundant. I can tell you redundancy, ask any real estate attorney, they will tell you the more forms I can put in front of a client when he's on the witness stand. You signed right here saying it was okay. You signed right there where you said it was okay. You signed over here where you said it's okay. Were you insane when you signed all these things? I've actually been in deposition. That's actually the dialogue they used. And what they're making a point is, now they're trying to change history. Oh, I didn't see it. Okay, well, how about this one? Didn't see that one either? Oh, I didn't understand it. Okay, how about this one? You signed 3 things. Don't you think you should have asked? You are going to win that case. So, yeah, doing the BSI is a great addition to a BIW if they do a BIE.
And then the BMI is only, or the BSI is only used if there's comments made on the BMI. So you don't always use the BSI. Exactly.
And Lindsay, you correct me if I'm wrong. Wouldn't you say more than half of the BMI, more than half of the BMIs have none on them?
I would agree with that. Yes.
Yeah. That's the most common, right? And that's what we want. We went successfully defended ourselves in a potential lawsuit where the person wrote down something about, the carpet was a little old and they wished they'd gotten a carpet credit. Okay, that's a weird thing to put on the BMI. But what they claimed in multiple claims is that no, I had mentioned smoking and I can't be near smokers, and my agent knew that. And she ended up buying a condo next door to a chain smoker.
Jim and Brenda just give some examples that they give their clients for the BMI, and that would be, does the property allow horses? Can I have a pool? And then, like you mentioned, Brenda said, you know, an example would be they don't want a neighbor who smokes or has a barking dog. So those are additional examples of
Beautiful.
BMI.
Yeah, because, you know, sometimes people, in fact, there have been lawsuits filed over barking dogs. The neighbor has a barking dog. There was a lawsuit filed because the neighbor's teenage sons played basketball at night. And the seller knew it and didn't disclose it to the buyer. And the buyer buys the house, moves in, and he's up all night listening to the neighbors play basketball. And of course, their claim was, if we'd have known that they do this kind of stuff at night, we would have never bought the house. We need our sleep. Absent a BMI, they won that lawsuit. With a BMI, how many times are they going to write that down? They're probably not. And that's the point. The point is they're not going to be able to claim it now after the fact. See, now, oh, no, I told my agent. You probably didn't. Again, I've worked with a lot of buyers. I've never had a buyer say, by the way, I don't want a house next door to anybody that plays basketball at night. You know, but that's what they'll claim afterwards. I like to use the phrase buyers have selective memory.
Mm-hmm. Those are all the questions.
Okay, great. Well, folks, thank you for listening. And again, as you use these two forms, if you have any challenge at all, or if you're still uncomfortable with them, give me a call one-on-one. Let me help you with it. I can tell you over half the people in the company have successfully used these forms. And again, repeating myself, they have frequently benefited the agent when the buyer now has a change of heart, and it was not the agent's fault. All right, let's move into the selected and new forms. It's going to be a challenge to get through this, but I'm going to zoom through this and not spend too much time on some of the minor ones and a little more time on the some ones that have a little more of an impact. Okay, this is the June 23 release. Like I said, there's 60 plus forms, I think almost 65, but many of them are simply a change in terminology. So the first form I want to talk about is revisions to the RLA. Now, on a 4C, not a big deal, you can list smart form features that will be included and excluded. And that's good to know because you can be aware of that when you are negotiating offers. And so that's a good thing for you to ask the seller if there's any of these smart form features they intend to take with them. Let us know. And if you're going to include it, let it put it down, and maybe I can put it in the MLS. That might enhance the marketing. Now, a more important change, and this is very important to be aware of, is the addition of paragraph 10B, presentation of offers. Now, so the presentation of offers, they begin by explaining that they can be submitted to the seller as they're received, or they can be collected and submitted to the seller on a specific date. And then they discuss the pluses and minuses of why a seller might want to have offers held and then present it as a group. Now, what's important to know is that B1 is default, and default says offers will be presented as received. And I will tell you, maybe I don't have a good idea of what most of you do. I only know what those who call me with questions do. But my impression is that many of you are holding offers for 2 or 3 days until you collect a handful, because you don't want to, send the offer over to the seller every single time. And that's perfectly fine. The good news is the form addresses this by informing the seller of the pluses and minuses of doing that. But if your intent and you believe you should be holding the offers, discuss it with the seller, and then have this, then you check this box that the seller is instructing you to not present the offers until a specific date. Now, here's what's a little weird about the form. By the way, these are draft revisions that have been through committee, already presented to Car Legal's already presented it to a select group of us that get on a conference call with Car Legal every 2 weeks, and this was presented to us. So I think this is what it's going to look like when they get put out in June. But I think there might be a change here. I'm certainly going to raise this issue, and that is, how do we know what date we're going to select an offer, present an offer? So that's a question mark there. So in that blank, you might put TBD or something like that, to be determined or something. I don't know. I think that form needs to be modified to the standpoint that when you take a listing, remember, this is the RLA, you have no idea what date you'll be presenting offers. But yet that's what the form sort of calls for. But do check this box if your way of doing business and your seller agrees is to, present offers in a batch, in a bunch. All right. Okay, cancellation of listing. Let me talk really briefly about that. Cancellation of listing. The change, and this is kind of important because a lot of agents didn't realize it. And so now they make it clear. You can check multiple boxes. You can check A and B if you want. And I recommend you select A and B. A means that even though you're canceling a listing, if they sell the property during the original listing period or any extension, and then they owe you a commission. B is within X number of days after this cancellation that they sell the property to somebody who's physically entered the property and you name them, then you're still owed a commission, even though you canceled it. So that's a nice form to be aware of. By the way, the reverse of this is true. Sometimes you have an opportunity to take a listing because it's just, been, quote, canceled. A lot of times it hasn't been canceled, it's been withdrawn. When you take a listing that already was in the MLS and is presumably canceled, you're going to want to ask the seller for a copy of the cancellation and then look for some of these check marks because they could owe a commission if they relist with you and then they end up selling the house during your listing period. Now they would owe you and the other party a commission. So get a copy of the cancellation, send it to me if it's not clear to you on what they should do. But that's important to be aware of. There are different circumstances where they might still owe a commission, even though it's a written cancellation. This is a very listing agent friendly form, the COL. It really gives you a lot of options to still collect a commission from a seller who presumably no longer wants to list with you. And you're not necessarily going to be their agent in the subsequent transaction. Okay. Notice I don't want to spend too much time on this except to let you know about this. And I will also say I don't have all the information yet, but City of San Diego just initiated their own local tenant protection act, which severely limits evictions, either no fault or at fault evictions. So we're going to have to factor that in. And we don't advocate that you are doing any property management. You're not supposed to. If you are, you want to talk to me about that. But you are taking listings that have tenants in them. And of course, so a little bit of tenant landlord law is going to impact what you do. So the first thing I want you to be aware of is that there is a notice of termination of tenancy. And, I need to look at the San Diego law, but elsewhere in the county, you can terminate a tenancy under certain circumstances, and that may be what you want to do in order to sell it. The form has been modified, and this is a brand new feature of the form. It starts out with a very detailed explanation to you and the seller, you, the listing agent. This gets separated from the form when you serve the notice. So this does not go with the notice of termination, but it gives you a nice explanation of some guidelines on how to do this form. And again, most of you do call me, walk you through a few things, ask you a few questions. And especially if it's in the city of San Diego, we're going to want to factor in the new city ordinance. So there's the form in some detail. I'm not going to read through it. It's in your handout, or after June, I think it's going to be around June 20th or 22nd, something like that. This form will be available to you in car. Call me if you have any questions about this at all. Okay, so basically the thing is, it makes it real clear whether the property is covered by TPA, the Tenant Protection Act, the famous AB 1482, the one many of you are familiar with. Certain properties are covered by TPA, other properties are not. That's one of the first things I ask you, is a few questions about the ownership of the property as to whether TPA comes into effect or not. And if it's affected by TPA, then paragraph 2 is checked, and you have to follow the guidelines in paragraph 2. If it's not affected by TPA, then paragraph 3 is in effect, and you have more options to terminate a tenancy if it's not subject to TPA, the Tenant Protection Act. Again, notice how landlord has been removed and now housing provider is in the form. So this form had more changes than just terminology. That first page is significant. It gives you a lot of information and a place for people to sign it. And then delivery. It's important to understand that delivery of the notice of termination must follow this process. You can't pick one of these. Well, I'm going to do C. You can only do C after you've done A and B. You can only do D after you've done A, B, C, and D. And of course, if A is successful, you don't necessarily have to do B, C, and D. But if A is not successful, then you can go to B. If B is not successful, you go to C, and likewise all the way down to D. Okay. A notice of entry. There's a little bit of changes there, nothing super significant, but what I wanted to alert you to is Civil Code requires before a housing provider, I got to get the words right, enters a property or their agent, they are given a 24-hour written notice. And that includes property that you put on, on the market. So every time you want to show a property, you have to give the tenant 24-hour notice in writing. And of course, the form you would use is the NOE, and the NOE specifies when you're going to show the property, the date and the time, and a place for the housing provider, which is new word for landlord, or the agent signs it. All right. And then delivery of the notice. Now that's a pain in the neck, right? So there is a form called a notice of sale and entry that gives you the right to enter the property after a 24-hour notice that is verbal. So you create a little log if you have a listing with tenants in it, and you write in the log when you left the voicemail, "Hi, Bob, we're going to be showing the house tomorrow. It's got to be 24 hours, so I can't say at 11. I can say 12, or I can say 1. And just wanted to give you a heads up. We have a key, so no problem. Or if you don't have a key, that's going to be a problem. You should have a key. The landlord should have a key. But if you don't, then you're going to have to coordinate getting a key. A little tip, don't ask for permission to show the house. Because what you're going to do is introduce the concept on the tenant's mind that they have a right to deny you entry. They do not. Civil Code does not give them the right to deny entry. Now, if you have a good tenant, they're going to cooperate with you. You're going to say, "Hey, I want to show the house tomorrow. We're going to be showing the house tomorrow at 1 o'clock. Oh, Walt, 1 o'clock doesn't work at all. I'm going to be silent for a minute. If they say, "How about 3? I'm going to cooperate with them. This is a cooperative tenant. "Yeah, no, I think 3 can work. I'll have to make a few calls, but yeah, I appreciate it, 3 o'clock. But if you say, "I'm going to show the house at 1, notice I don't say, "May I show the house at 1? Do not do that. I'm going to show the house at 1. If they say, "Okay, great." If they say, "How about 3? Make it 3. If they say, "Nope, sorry, that won't work for me." You know now you got a tenant who believes you would need their permission to show the house. So you politely say, "Is there a better time? I have to get back to you." This is how some tenants, those of you who've dealt with tenants when you're trying to show property, you're the listing agent, you know what I'm talking about. You're going to have to get a little firm. Call me if you need to, and politely explain, I'm not so much looking for permission. I'm trying to coordinate something that doesn't disrupt you, but we are going to be showing the house. We have the right to do that. Okay, so I wanted you to be aware of that form. And so, again, it lists the housing provider. It has a place for the how you deliver the notice. A big change as a result of civil litigation is cash for keys. Everyone on this call, if you are ever going to be involved in a cash for keys situation, is pay attention to what I'm about to say. The courts have held that a landlord offering cash for keys is a hostile act and amounts to constructive eviction. Constructive eviction is acting like you're evicting somebody when in fact you have no right to do it. And amazing. If I call somebody up and say, "Hey, how about if I give you $10,000 and you move out now. I know your lease is not up for another 7 months, but the landlord will give you 10 if you move out. That is a hostile act, and the tenant in that lawsuit, it just went through appeal, and the landlord lost, the housing provider lost. The tenant won significant damages because, unbeknownst to anybody, yours truly, everybody on this call, we had no clue that the courts would consider us offering money for them to get out is a hostile act. Sounds kind of friendly to me, but that's the deal. So this form has been, notice it's all red, red's changes, right? This has been significantly changed to make sure that the impression is clear. This is a offer from the tenant to accept cash and give you early possession. So be real careful if you're going to be involved in a cash for keys situation. Maybe call me. I can review it with you a little bit. But in a nutshell, keep in mind that if the tenant says to you, you can say to the tenant, look, if you want to have early termination in exchange for cash, you can certainly propose that to me. You can make that verbal comment and you can get away with that. Don't send an email. The landlord would like to give you money if you'll move out early. That's exactly what happened in the lawsuit that I mentioned earlier. So this form, I won't go through it in too much detail, but again, the first page of the form is an instruction sheet it's for you as the listing agent and the seller. You remove that, and I won't go through it. I kind of explained it briefly, and then you fill out the form, and it has all the provisions. It's pretty straightforward. The form that hasn't changed much in its effect. It's changed in the terminology and the way it's phrased to eliminate the appearance that the landlord is initiating this, that the housing provider is initiating this. Paragraph 3 probably doesn't affect you because we don't represent, most of us are not representing REO properties at this time. Some of you will. I know some of you on this call have done REO business in the past, so then this paragraph 3 will come into effect. This is the occupant's obligations. Pretty much doesn't change too much, and limits on the payment, surrender of the property. Pretty straightforward form. So wanted you to be aware of that. Seller's payment to buyer's broker. I know this question comes up a lot, and CAR finally, the form's only been out a little while. They quickly decided to put on the form a paragraph explaining when a seller paying buyer's broker is an SPBB is appropriate. So these 3 things have to be true in order for the offer to ask the seller to pay the buyer's broker, and then if you are asking them to do that, just asking the seller to pay the buyer's broker, the buyer's agent, you attach this form to the SPBB. But these 3 things have to be true. I'm sorry. Number 1 is there is already a buyer broker agreement in place, a BRBC. Number 2 is the obligation of the buyer to pay the buyer's broker exceeds the amount of the CBB in the MLS. So the MLS says 2%, you have a buyer broker agreement for 3%, so it exceeds it. If you have a buyer broker for 2% and the commission in the MLS says 2%, then this form is not appropriate because you're asking the buyer or the seller, you're asking the seller to pay the difference, the additional obligation of the buyer to his buyer broker. So the obligation in the buyer representation agreement in the BRBC has to exceed what's in the MLS. And then the third thing, the buyer wants the seller to pay for. And of course, the buyer should be informed that, that is going to impact your offer because that's going to be another expense. It's like asking the seller to pay closing costs. And he may not want to, and you may not compete as well against another offer that's not asking for closing costs. So that's that form pretty much. Seller's purchase of replacement property. I just wanted to show you the one change and remind you of paragraph 1. Paragraph 1 is extremely important that you understand it. I think most of you do, but as a quick review, there are 2 contingencies although there's an A, B, C, but there's only two contingencies. Seller's purchase of replacement property. If the seller's selling their house, but conditioned upon them buying a replacement property, then you would use this form, of course. And the first contingency is finding a replacement property. That's a separate contingency, and that's in the boilerplate. Now, if they've already found a property, because it's in the boilerplate, you have to check B and say, ignore A. We've already got a property. And then if you want C to be in place, you have to check the box. There have been a couple of instances where agents have not checked C, and the seller fully intended not to sell their house unless they can close escrow on a replacement house. Very few sellers say, yeah, I'll sell my house if I can find one. They say find one, but what they mean is close on it. And so you want to have that conversation with them. Look, if you find one and you don't close, would you still sell? I did have one time a buyer say, yeah, I'll move in with my mother-in-law. He got along with her, apparently. So, and this form didn't exist, but we were kind of writing this kind of stuff on offers, much to the chagrin of some agents because they would be written pretty poorly. So Carr years ago came up with this form to protect us. So if a rare seller says, no, all I need to do is enter into escrow, that's going to be rare, as most of you probably know. They're going to say, I want to close on that, of course. So be sure you check C. And of course, the time frames, if B is checked, are per the agreement. If B is not checked, then you can determine elsewhere on the form when the time frames start for the time frames in the RPA. All right. And then it gives a little more detail on the buyer's right to cancel and the seller's right to cancel. Basically, if the seller doesn't find a house or close on a house in the time frame specified, the buyer has the right to cancel. And if the seller cannot, in fact, find a house that they're happy with, or they do find a house, but they can't close on it, they have a right to cancel. So that's pretty straightforward. Okay, the TOP, tenant occupied property, the change is that if there are adults living in the house other than the seller, if you use a TOP, the seller must identify those people. And the agreement also says that if the seller is going to remain in possession, no tenant may also remain in possession at the same time after close of escrow, because you want the tenants out. It's easier to get a seller out. Not always, but usually sellers are willing to get out. Sometimes tenants are not. So, okay, the probate purchase agreement, one kind of minor change and another I just want to bring to your attention. And one is that they didn't have a time frame on if court confirmation is required on when that court confirmation had to be obtained. So they put in the default 60 days. So if you can't get court confirmation in 60 days, or you can change it, make it longer, make it shorter, the buyer would have the right to cancel. Okay. Now, the other thing is they made it a little clearer. If the property is in probate and it's being handled by a court, the liquidated damages clause is invalid. No court is going to allow another court to determine whether or not liquidated damages apply and whether or not cancellation applies. The probate court's going to speak for themselves. Now the question is, what if it's under probate law? It is sort of under the guidance of the court, but the Independent Administration Estates Act, the IAEA, basically is not an avoiding of probate, but an avoidance of most of the administrative processes of probate, and therefore it's cheaper. So if it's being administered if the sale is being administered under the IAEA, the question is, can a liquidated damages clause be in play? Because there isn't a court overseeing it directly. And that's that's subject to interpretation. So Carr simply said, if you think that you're protected by liquidated damages as a buyer, by the way, probation courts frequently, when they do impose a penalty for a buyer defaulting, it's usually 10%. So you want to make sure any buyer that's buying an offer under a probate court jurisdiction they make sure they do not default on that contract. Because if they do, the court, and they can get a judgment and put a lien on any real property you own. And that has happened. I'm familiar with it. So be careful with that. So a buyer may want to make sure that liquidated damages provision does in fact protect them in a transaction. And somebody's saying, oh yeah, the court's not involved. Yeah, I'm okay with that. And maybe not. So they're saying get an attorney and have the attorney review that. Okay. Hope I didn't get in the weeds there too much, just let you know. Now the BCO, the SCO, and the SMCO has one change. It's universal to all of them. And it basically explains the so-called appraisal gap. And so basically it's a very good explanation. If you just read through this, it's very good. If somebody says they're going to buy it for $1 million, but they want it to appraise for $950, and if it appraises for at least $950, they'll still buy it, and they can't use their appraisal. So it appraises at $950. All right, that they can't use the appraisal contingency to get out of it, even though it didn't appraise for $1 million because they wrote in $950. What happens if the counter says $1.2 million? You know, does it still have to appraise for $950? No, it has to appraise for $1,150,000. It's the appraisal gap that is governing, represented by a purchase price initially offered at $1 million and an appraisal contingency lowered threshold to $950,000. So what you're doing is establishing a gap, and that gap, that dollar amount carries forward. So hope that's kind of clear. Read through this. If you have any questions, call me, but it's pretty straightforward, I think. All right. So that's on all three counter offers, to make that clear. An assignment addendum, the biggest change there is they've added a place where you're replacing one buyer, but you're keeping one of the original buyers. So that comes up sometime, and the form works a little better now that you have that option. So not both buyers aren't being replaced. Just one buyer taking, husband's got a lousy credit report. So we'll take husband off, keep the wife on, and add mom. Okay. See, so keeping one buyer, replacing the other buyer. Notice a buyer to perform. Another situation that's come up frequently, and now they've addressed that, is they've made it very clear that if a notice to perform is served too early, it's invalid. So if you have a notice to perform and you have until, the 20th to remove contingencies, and they serve you a notice on the 16th, it's too early. You can serve it 2 days early, not 4 days early. So, now, if the notice to perform includes other contingencies that are in the time frame, so, your physical inspection was 15 days, your loan was 20 days. And so they want the physical inspection and the loan removed, and they give it to you on 15th day. Well, it's good for the 15th day, for the physical condition, but it's not good for the loan. That's what this says. I hope I said it a little clearer. Maybe not. I'm going fast because I got about a minute here and I got to wrap up. We're real close. Cancellation of contract. There is a new paragraph at the beginning, and it basically explains what most of you know. If you've ever talked to me, you've heard me go through this whole thing. It's pretty straightforward that cancellation has to be done in good faith. And whether or not a client has a right to cancel is up to the client to determine. We can't opine on that. Yeah, you can cancel. I mean, the phrase I use is, the contract says that given these circumstances, you may be able to cancel. That's what the contract says. Now, whether or not, all these circumstances are accurate that I'm hearing, or whether or not you have the right to cancel, that's ultimately up to the buyer and the seller to determine. And it talks about the fact that even though you cancel, doesn't mean you automatically get your deposit back, or if the other person canceled when you don't think they had a right to, that the seller gets to retain the deposit. That escrow is going to hold that deposit till there's a mutual agreement. And if you have any issues about cancellation, you should talk to an attorney. It's basically a pretty simple explanation at the very beginning of the cancellation form to explain that. Okay, the DIA has been modified slightly, and I love it because we still have problems with listing agents not providing us reports from previous escrows. That happens from time to time. If that ever happens, call me. I'm pretty successful at getting it. They added a sentence literally to say that the SBQ and the ESD states that the seller has to provide any relevant documents, including reports and inspections or inspection reports, whether past or current, in the seller's possession. They have to provide that. So that was just added, give you a little bit more. It's in the contract, it's in the RPA. Now it's also in the DIA. Okay, transfer disclosure. 3 forms have all added this one line, which is important to be aware of. And that is, if the property is a duplex, triplex, or fourplex, then the TDS is for one of the units, and additional TDSs must be provided for other units. So if you sell a fourplex, you're going to get 4 TDSs. Sell a duplex, you're going to get 2 TDSs. All right. Same with the SPQ. Property is a duplex, triplex, or fourplex. The SPQ is for unit number blank, and additional SPQs must be provided. And it's the same with the ESD. You have to do additional ones for additional units. All right, the last thing to cover, and I'll get that done in about a minute, is the SBSA. The SBSA made 4 significant changes in the body of it. And I'll take you through those. Go, here's the table of contents, and they had to renumber everything because they added a few things. The first thing they added was A15, and they discussed the preliminary title report and the importance of the buyer reviewing it. And I love this, clicking on all the links. If ever there are problems with transactions that the title report revealed, but the agents weren't aware of it, it's frequently because nobody clicked on links. They got the PR, they put it in the file. The buyer got the PR, didn't know what it was, and put it in the stack of papers, and other papers, he didn't know what they were. He got an email, he looked at it, he didn't click on any links. The links are what give you some important documentation about this property. So this 15A, or A15 rather, talks about that. The electrification of energy source, jurisdictions one by one. I think San Francisco has already done it. This is a statewide form, obviously, putting a ban on gas appliances. So if you're going to replace your gas appliance or you want to install a new gas appliance, you may not be able to. So DCAM simply addresses that. F, homeowner association, long paragraph. At the end, what it talks about is just an informational that the CC&Rs may have discriminatory covenants and they're not valid and they can be removed. So it just alerts them to that. And then finally, an important note on solar is that if you have net energy metering, and what net energy metering is, you can sell back the power that you don't consume, that your panels are generating. Now, the bad news is SDG&E has successfully lobbied. They sell you power for $1 a kilowatt, but they buy it for 50 cents. So you got to buy it from them when it's dark for more money than they'll buy it from you when it's light. I mean, that's I don't know how they got away with it, but they did. What this says is that these rates are subject to change. How much money a seller is getting because of net energy metering from SDG&E, or how much credit he's getting off his bill when he's using power at night. It can change because these rates can change, and it simply alerts you to that. Folks, that's it. And I hope I didn't go too fast. I hope I went fast enough not to keep you too long. Lindsay, do we have any questions?
Yeah, Ron wants to know, on the notice of showing property, he was told by CAR that it can only be during business hours, which are 9 to 5, Monday through Friday.
Yeah, you misunderstood CAR, I think. 9 to 5 is accurate, but you can also show property on weekends. The law has actually specifically recognized, courts have specifically recognized, same with open houses,
Well, I understand that, but that's what CARD told me. They said,
I'm
you gotta
amazed.
go to business hours, because it says in the form, business hours. And if you go to get the definition of business hours, they said it was Monday through Friday, 9 to 8 or 9 to.
I'll confirm this is still true, but you're correct. The form does say business hours. So what the code addressed in the lawsuit, actually it was a lawsuit that addressed, is that for real estate agents, weekends are business hours. That's what they said. So they said, oh yeah, you can only do it during business hours, but it includes Saturday and Sunday. And then as far as open houses are concerned, there has to be a reasonable accommodation for the tenant that you can't do it every weekend. And so I think the business hours, I think Carm didn't give you enough. The phrase I like to use is the brevity of the person who answered that question made the answer inaccurate. The answer is correct. You can only show property during business hours. But what they didn't say is there's civil litigation that includes the weekend for real estate agents.
Okay,
It's
because
business hours.
the reason I called Carr is because the person's attorney or had an attorney that told her this. And so
Right.
I called Carr and they said, that's business hours, Monday through Friday. So if you could check that out.
I'm going to check that out to be 100% certain. I love Carr. I love most of those attorneys. You know, recognize they have 45 attorneys, some better than others. Some questions are answered a little more thoroughly. I mean, I have 2 or 3 names and they're the very top of the food chain over there. And that's where I get my information from. And I'll confirm, but I think weekends does count.
Jeannie Dominguez asks, can asking the seller to pay the difference in the buyer broker agreement possibly hurt your buyer in multiple offers? Like if the buyer broker agreement says 2.5, but the MLS says 2%, but the seller gets multiple offers.
Well, that's exactly true. And remember, I referenced that the third thing has to be the buyer wants the seller to make up the difference. And of course, you should review that with your buyer. So yeah, Jeannie, you're exactly correct. You should review with the buyer that, look, this agreement says 2.5. The commission being offered through the MLS is only 2. So you're going to owe 0.5%. We can ask the seller to pay it, but I've been told they got 4 other offers. So they're going to factor that cost. That 0.5% is going to be another $6,000. That's going to be factored in. Do you still want the seller to pay it? So that's true. Yes, that needs to be addressed.
Jim Supples, this is regarding the line item added to the TDS, SPQ, and ESD.
Yes.
What about ADUs, granny flats, casitas, attached or detached?
That's a great question. Right now, I would err on the side of caution and make a separate inspection. I'm a TDS and SPQ for each unit.
That's
So
it.
although it's not a multiple unit, there are 2 separate buildings on the property.
That's it for questions, Walt.
Well, that's great, folks. If you have any other questions that you have that you didn't want to share with the group or something comes up, don't hesitate to call me. Thanks so much for joining me. And again, just to wrap up on those 2 required forms, if there's any concerns you have on that, then talk to me one-on-one and I'll help you to maybe feel more comfortable with those forms.
Thank you, Walt.
Have a great rest of the day, folks.
You too.